Welcome to Legal Awareness web series. We have a very distinguished and eminent guest today, Professor Tony Blackshield, who is a professor emeritus at Macquarie University, has taught at University of Sydney, has established the law school at New Wales, has been writing on Indian judicial response on various issues. I read his article on capital punishment in India, on pith and substance, a very eminent and leading authority on constitutional law and comparative constitutional law. I'm going to talk to him today about the basic structure case of Supreme Court, that is Keshavananda Bharati case. Welcome, Professor Tony Blackshield.
Thank you.
My first question is, why the amending power in a constitution is important? I'm aware that no one generation can have the monopoly of wisdom, and the founders should not govern any country from graves. But in your opinion, as an expert of comparative constitutional law, why every constitution must provide for amending powers?
Because a constitution is written at one particular point in history, and as history goes on, the conditions change, the politics change, the culture changes, the needs, the technology changes, and so you must be able to change the constitution. But I come from Australia, and it's always interesting to compare Australia's constitution with India's constitution. The Australian constitution is much too hard to change, and the Indian constitution is much too easy. You don't have to change it all the time. The Americans, since 1791, their constitution came into force, more than 200 years, they have had 27 amendments in all that time. In India, I lose track, but it's already well over 100.
Right.
Yeah.
In fact, some provisions of our constitution can be amended by simple majority.
I know.
And they cannot be even called as amendments.
That's,
So
yeah.
you amend the constitution and yet they are not deemed as amendments.
And one important part of the constitution is to control the parliament, and so you cannot just have the parliament controlling the constitution.
Well said.
Yeah.
My second question is, since you are so closely involved with our constitutional and judicial developments, what must be the reasons for the Supreme Court of India, which starting from Shankari Prasad and Sajjan Singh was conceding absolute power of amendment to Parliament, to suddenly apply brake and say that Parliament cannot amend the fundamental rights in our constitution?
Well, again, it's interesting to compare India and Australia, because we both have the same problem. We tried to, in our constitution, we tried to combine the British idea of parliamentary sovereignty with the American idea of judicial review, and they are not really compatible. So by putting the two together and trying to have them both work, both countries created a real problem. And in India, it has finally been solved by the case we're talking about, Keshavananda, which means that ultimately that tension is controlled by the judiciary. In Australia, the balance has remained with the Parliament. Our High Court, our Apex Court, has been very timid, not quite believing parliamentary sovereignty, but too much.
Maybe the British influence, where you have supremacy of British Parliament as the first principle of British constitutional law. After all, Queen continues to be the Empress of Australia.
Yeah, that's true, yeah.
So you had written about prospective overruling prior to Golaknath's judgment. And eventually Supreme Court said that we are adopting this prospective overruling doctrine. So can you tell us about your article and the context in which you had written, because subsequently what you had written was accepted by the Supreme Court of India?
Well, you mentioned Sajjan Singh, the Sajjan Singh case, And it's true that until that time, you see, when the Supreme Court started, faced with the problem I've just talked about, the Supreme Court in the 1950s was leaning very much to the parliamentary sovereignty side, and so reading the Constitution very literally, one thing about a Constitution, it's bigger and more important than a statute. You can't treat it just like an ordinary statute, but they did. And it's in Sajjan Singh that again they said, yes, Parliament can amend the whole Constitution, but two judges, Hidayatullah and I think the Chief Justice, Gajendra Gadkar. Those two raised the question. They didn't decide to overrule the earlier cases, but they did see that there was a problem. And I was in India at the time, and I was very excited, so I wrote this article about the problem. And I just said there are only two possibilities. Either the Parliament can amend the Constitution whenever they want to. No, either Parliament can amend the fundamental rights whenever they want to, or the fundamental rights cannot be amended at all, and neither of those solutions is satisfactory. So there's a problem. And that's really all I said. But I said, if they decide that the Parliament can amend the fundamental rights, then they should use this American technique, prospective overruling. And what that means is this. Normally, when the Parliament makes a law, that law only operates for the future. Cases that happened before that law are not affected. But normally when the court declares the law, it is retrospective. That is, we assume that what the court now says always has been the law. But in America, in some of their constitutional cases, they could see trouble about upsetting everything that happened in the past, so they started saying, we declare that the Constitution means this, but this decision will only operate from the date of today's decision. And then they fiddled with it a bit more, but that's what I said. If the Indian Supreme Court does decide that Parliament cannot amend the fundamental rights, they should make it prospective only. And when the Golak Nath case came along, my article was not yet published, but it was in page proof, and all the judges and all the barristers had page proofs of my article. And by a majority, that's what they did. So then people said it was my fault.
But it is Indian Law Institute Journal, as you know, that the Chief Justice of India is the chairperson of Indian Law Institute.
Yes.
And all judges are very closely involved in the functioning of Indian Law Institute.
Yes.
So they had access to your article even prior to its publication.
Yes.
So my next question is, don't you think that till Golak Nath, our Supreme Court reposed faith in the Parliament, because Parliament consisted of people who had led countries' freedom struggle? When they found that Parliament is abusing its amending power, they withdrew this trust, and therefore Golak Nath 6-5 decision, they said you will not amend the Constitution anymore.
Yeah.
You think so?
I think by that time, and this was one of the reasons I talked about prospective overruling, a lot of the controversy had been about the right to property. And the problem was that the new Parliament back in the 1950s needed to do land reform, needed in particular to break down the ownership of some big estates by the zamindars, the absentee landlords, and give it back to the people, the farmers, but the right to property was getting in the way of that. Now, how big a problem it was, we're not sure. There had been some judicial decisions that did create a real problem, but the bigger problem was that because there had been a few decisions, the right to property looked like an obstacle to land reform. And so bit by bit, many amendments, one after another, tried to deal with that problem. And so the idea of prospective overruling was, okay, we've worked out the right to property, let that stand, but they can't amend it anymore.
Correct. My next question is, do you think that the basic structure theory has no constitutional basis, as the text of the Constitution nowhere talks of anything called basic structure, and it is little undemocratic that judges who have not been elected by the people sit over judgment on people who have been elected by the people?
No, I think the idea of basic structure or similar ideas of something more fundamental underlying the Constitution, different versions of that idea crop up wherever there is a written Constitution. I read recently a Canadian case where they actually used the phrase basic structure. And I thought, oh, they must be citing the Indian Supreme Court. But I looked carefully and they were not. But still, there was the same idea. And in different ways, judges in every country have tried to say there are these fundamental principles at the basis of the Constitution, and they are what make the Constitution really important. One of the things I've only learnt while I've been at Nausar is that the Indian court, some of the barristers who argued the case in the Supreme Court, they took the idea of basic structure from a German scholar, Dieter Conrad.
Right.
And after the decision, I believe he came and talked about his theory of basic structure. So that's where it came from. And again, it reflects a basic idea that has cropped up in many ways in German constitutional law. So it crops up everywhere. The Constitution is, and this is part of what I mean when I say the Constitution is more than just a statute. And remember, you talked about the British tradition. Britain doesn't have a constitution at all, but they do have those basic underlying principles.
Correct. Like rule of law.
Yes, yes.
So, in your view, do you really find any ratio in Keshavanand Bharati case? Because many people say you have so many judgments and therefore there is probably no ratio decidendi in this historic case.
What all the majority judges have said generally is that there are essential features in the Constitution or a basic structure in the Constitution which cannot be changed. That basic idea the majority are agreed on. When it comes to saying what are these basic features, no judge will tell you all of them, but most judges tried to give some examples: secularism, separation of powers, federalism, some fundamental rights, and you can get a general consensus from that. But it's true that there is one judge, Justice Khanna, whose reasoning is a little bit different from the others, and I've taught about the case. I've tended to tell the students to look at his judgment and take that as the ratio decidendi.
Very interesting, because Justice H.R. Khanna's judgment, which tilted the scales, was also not very clear, and it took some years when he decided subsequently Indira Gandhi versus Raj Narayan that he clarified his judgment in Keshavanand Bharati.
I know.
So my next question, Professor Tony, is that as you know that this case was argued for some 66 days, passions were high, government was very anxious to know which way the judgment is going. They decided supersession of judges.
Yeah.
But there are problems, because suddenly, on the day of the pronouncement of judgment, Chief Justice Sikri circulated what he called that 1.5 page note, view of the majority, without consulting other judges.
I know.
And 9 judges signed it, 4 judges did not sign it. So don't you think that it is strange that Chief Justice of India suddenly comes up with something as strange as view of the majority, and 9 judges sign it, 4 judges don't sign it, and that becomes the final order of the court?
If it becomes the final order, yes, that's very strange. Most constitutional courts these days, now that we have modern technology, they try to put out some press release explaining the decision, a summary of the decision, a judgment summary they call it, but they make it very clear that although this is to help you understand what has been decided, it is not authoritative. It is not a legal ruling. It's an attempt to explain to people what the ruling is. Now, if that's what Sukri was doing, that's fine. But to take it as authoritative, whether they've signed it or not, the authoritative thing is whatever you can get out of the judgments.
Correct.
Yes.
And you know that this is such a case that 2 judges, Justice Shalhat and Chief Justice Sikri, were judges in Golaknath, and ideally they should not have been there in Keshavanand Bharati. Similarly, the dissenting judge A.N. Ray, who was subsequently appointed as Chief Justice of India, was a judge in R.C. Cooper and Madhav Rao Sindhia, and therefore at least these 3 judges should not have been there in this on this bench. And there were 3 other judges who were available, but they were not picked up for this bench. So you have all kinds of controversies about Keshavanand Bharati.
This is a general problem with the Supreme Court of India, and it's a problem because this court, uniquely in the world, has to cater for so many thousands and thousands of cases. Mostly in South Africa, they have a special constitutional court, and all the big constitutional issues are decided by that court, and there are 11 judges, and every one of the 11 judges sits in every case. In Australia, we only have a High Court of 7, but in any constitutional case, the rule is all available judges will sit. So usually that means 7, and always it means at least 6. But with the Supreme Court of India, with the vast workload it has to cope with, you can't do that. And so Golaknath was 11 judges, I think. Kesavananda was 13 judges. And I think this is the biggest bench they've ever had.
Right.
But that's still not a majority of the court. And
no, it was a majority at that time.
Right. Yeah. But there were other judges who perhaps should have been there.
Yeah. I'm talking of judges who have given a judgment which is now being considered, because Golaknath very much, whether it was correctly decided, was the central issue in Keshavanand Bharati.
Yes.
Therefore, judges who already had expressed their opinion in Golaknath should not.
No, I would not agree. I would not agree with that. I would not say that those judges should not be there, but I would be sympathetic if you say there are other judges who should have been there. Look, in the High Court of Australia, in the old days they had a lot of very boring cases, and we now have a separate federal court, and it does all the boring cases. But back in the old days, a lot of High Court cases were first heard by one judge, and then it would go on appeal to a larger bench. And it happened several times that the judge who had given the first judgment then sat in the appeal bench hearing an appeal against his own judgment. And I think there's a case where one of those cases then went to the Privy Council, and the same Australian judge sat in the Privy Council. So, yes, all the time, if you have a court that's dealing with sitting all the time, often they're going to have to deal with issues they have had to deal with before, But when they hear new arguments, they might change their minds.
But that is what generally judges will say. Recently, Justice Arun Mishra,
Yeah.
he referred he gave a judgment, and then it got referred to 3-judge bench, and then he headed the 5-judge bench. But I believe that propriety demands that in such matters the judges should recuse themselves, because we have a bigger court, so there can be other judges who can decide that.
Yes, and maybe that makes a difference. Since you can't include everybody, maybe you should have a different lot each time.
Yeah. So,
but of course, a lot of the problem with the Indian Supreme Court is that so often you have benches of 2 judges, and this means that the same issue is considered by 2 different 2-judge benches, and they disagree with each other, and this is going to happen all the time.
It happened. I am aware of cases, one bench decides one way in the morning, and another bench post-lunch decides in an entirely opposite manner.
Yeah.
So now finally, let me just put 2-3 more questions. Our Supreme Court, even in Keshavananda Bharati, as you know, it gave some illustrative list of features it calls basic structure, but it did not define what is basic structure. Do you take it as a major omission or shortcoming of Keshavananda Bharati judgment?
No, I think that's the essence of the decision, because what it is saying is that yes, the Parliament can amend the whole Constitution, including the fundamental rights, but the ultimate watchdog is the Supreme Court. And if a particular amendment goes too far, then the court will stop it. Now, we said earlier the conditions of constitutions change, but the conditions in which a change may or might be acceptable, they will change too. And so the court is not going to give you a definitive final list of the things the Parliament cannot touch. Parliament can amend the Constitution. We are the ultimate watchdog. Let the Parliament amend the Constitution, and we will tell you whether they can do it or not.
All right. So, I would say that in all your classes, your class will end with a song you would write on a Supreme Court judgment, and you have written a song on Keshavananda Bharati judgment as well. So may I request you to kindly sing the song you have written on Keshavananda Bharati?
I will, because I had sung to the students here some of my Australian songs, and they said I must write an Indian song. So here it is. What a great case, Kesavananda. Our Constitution the Parliament's able to change. Change is okay, mutatis mutanda, but some basic structure must still be kept out of their range. This is the court's perfect solution. Let's just confirm that the scope for amendment is vast. They can amend the whole Constitution, but we'll still control them and roll them whatever they've passed. Federal polity, secular quality, republicanism is ours. Dignity, freedom, and rights when you need them, and then separation of powers. Now the top court has the final potential. Judges' supremacy now is secure in its prime. We will decide what's really essential. We'll let them know what we're thinking, one case at a time.
Thank you so much, Professor Tony Blackshield. It was a pleasure talking to you. We wish you many more years in academia, and I'm sure that you would keep writing, keep visiting India, educating our students. Thank you so much.
Thank you.